Lease renewals, your questions answered. A commercial lease is a form of legally binding contract made between a business tenant and a landlord. It outlines the rights and responsibilities of both the landlord and the tenant during the lease period, and gives the tenant the right to use the property for business or commercial activity for a set period of time. In return for this, rent will be paid to the landlord. Hi, I'm Felix from Blackstone Solicitors, and in this video, Lease Renewals, your questions answered, I'm going to discuss some frequently asked questions about commercial leases. 1. What happens to my lease when it comes to an end? If you occupy a property for business purposes, you should have the right to renew your tenancy when it comes to an end. However, there are a number of exceptions to this. The Landlord and Tenant Act 1954 allows the tenant, in this situation, to renew his or her lease at the market rent but otherwise on terms to be agreed between the parties. The maximum new term to which the tenant is entitled is 15 years, although longer periods can be agreed with the landlord. 2. What does it mean if my lease is contracted out of the Landlord and Tenant Act 1954? It is possible for a landlord and tenant to agree before entering into a commercial lease that it will not continue when it comes to an end and the tenant will have no right to renew. If a lease is contracted out, there should be a clause in it confirming this and a statutory declaration sworn by the tenant in the presence of an independent solicitor. The statutory declaration is usually kept with the lease. If your lease is contracted out, you have no right to renew. If this is the case, just because you have no right in law, it doesn't mean you can't approach the landlord and see whether he or she is willing to negotiate. 3. Can the tenant apply to the courts to renew the lease if the tenant has already agreed to contract out of the Landlord and Tenant Act 1954? No. If the landlord and the tenant have already contracted out, then when the lease has expired, the tenant will be unable to apply to the court for a new tenancy. 4. What forms are used for renewing and terminating the lease? Assuming that the parties have not contracted out of the Landlord and Tenant Act 1954, each party will need to use a specific form to end or renew the tenancy. Landlords must use a Section 25 form while tenants must use a Section 26 form. If the landlord has already proceeded with a Section 25 form, the tenant cannot use the Section 26 form. Similarly, if the tenant has already commenced with a Section 26 form, the landlord cannot use the Section 25 form. 5. Is there anything the landlord can do to stop a tenant serving a Section 26 request? Yes, the landlord can serve a Section 25 notice on you terminating your lease on a minimum of 6 months, and a maximum of 12 months, notice. The earliest date on which a landlord can serve a Section 25 notice is the same as that on which the tenant can serve a Section 26 request. 6. What are the prescribed grounds under which a landlord can oppose granting a new tenancy? Under Section 30.1 of the Landlord and Tenant Act 1954, the grounds on which a landlord may oppose an application for a new tenancy are: if the tenant isn't keeping up with repairs as he or she is obligated in the lease, if the rent is regularly late, if the tenant is in breach of their lease obligations, that the landlord will offer, provide or secure the provision of alternative accommodation for the tenant, if the landlord needs possession of the property in order to demolish or reconstruct it, and if the landlord wants to live in the property or run a business from it. 7. I currently sublet part of the premises in my lease. Will this stop me renewing it? You must be in occupation of the premises in order to have the right to renew your lease, so you have no right to renew sublet parts. You can serve a Section 26 request for a new tenancy just for those parts where you are in occupation. When should the forms be sent to the other party? The parties can send a form to the other party no less than 6 months and no more than 1 year prior to the end of the tenancy. Neither party can ask for the tenancy to end prior to the end date specified in the lease. 8. What happens if neither the landlord nor tenant has submitted a notice? Assuming that the landlord and tenant have not come to an agreement and notice has not yet been served, or it has been served but it expires after tenancy expiry, the Landlord and Tenant Act 1954 provides that the tenancy is continued until it is brought to an end either by a Section 25, 26 or 27 notice, by court order, by the grant of a new tenancy, or by forfeiture or surrender. 9. Are there any advantages if I do have to leave the premises as a result of the landlord proposing renewal on the grounds of redevelopment or own occupation? The landlord must pay compensation when you leave the premises as a result of a notice served by the landlord on the grounds of redevelopment or own occupation. 10. I want to renew my lease. Should I go ahead and serve a Section 26 request now, or wait and see whether the landlord serves a Section 25 notice? The longer the landlord leaves it to serve a Section 25, the more the potential advantage there is for you by serving a Section 26 request. If the landlord has not served a Section 25 notice several months after he could first have done so, you can serve a Section 26 request giving the maximum 12 months notice to expire following the end date stated in your lease. 11. Will the rent stay the same after the Section 25 notice or Section 26 request has expired? The rent will stay the same unless either landlord or tenant has applied to the court for an interim rent to be fixed. If you need legal help with commercial leases, contact us at Blackstone Solicitors Limited. We have offices in Manchester and central London and have clients across the country. If you found this video helpful, like it, share it and tell other people about it. Press the subscribe button below to keep informed about our latest videos. Goodbye and thanks for watching.